A small claims courtroom mid-afternoon, the kind of quiet that settles in after a long docket. A woman in a cream blazer slides a printed document across the table toward the judge with total confidence, like she's laying down a winning hand. "This is the inspector's signed report," she says. "Dated, certified, exactly as required. I don't see what else there is to discuss." The judge picks it up, studies it for a long moment, longer than the document itself seems to warrant, and then looks toward the back of the courtroom, where a man in a polo shirt with a county badge clipped to his collar is sitting quietly in the gallery. "Is that your signature on this report?" the judge asks him directly. The room goes still. The woman in the cream blazer doesn't yet understand why that question is being asked at all, because in about 90 seconds, that one signature is going to unravel everything she walked into this courtroom believing was already settled in her favor. How does a dispute over a backyard fence end up here, with a forged signature sitting in the middle of a courtroom? To understand that, we need to go back 6 weeks, to the week a fence went up exactly where it was supposed to. Nadia Petrov had lived in the neighborhood for 3 years, running a small tailoring business out of a converted section of her garage, while raising her 2 kids largely on her own. Her home sat at the corner of a quiet cul-de-sac, and the backyard fence she'd had installed that spring had been permitted, inspected, and approved by the county's own compliance officer, a man named Gary DeLeon, whose signed approval she'd kept carefully filed away with the rest of her paperwork, along with the permit application, the contractor's invoice, and a handful of photos taken the day it was finished. Karen Voss had served as HOA president for just over 2 years. She ran the position with a level of intensity most volunteer boards didn't see, treating every decision as though it carried the weight of real legal authority, which, within certain limits, some of it actually did. She'd built a reputation on the street for following through on things, for not letting disputes simply fade away the way they sometimes did under previous board leadership, and for most residents, that reputation had mostly worked in the community's favor over the years. Her husband, Todd, mostly stayed in the background at meetings, though residents knew better than to assume that meant he wasn't involved. Karen took issue with Nadia's fence almost immediately, insisting it sat 2 feet closer to the property line than allowed, despite Gary's official inspection confirming otherwise. She'd apparently measured it herself one afternoon while walking past, using nothing more precise than a rough visual estimate against the property markers she believed she remembered from an old community plat map. When Nadia calmly explained that the fence had already passed inspection, Karen's response wasn't to check the permit. It was to start building a file of her own, one that, weeks later, would include a document nobody at the county had actually signed. That decision is where this story actually begins. Karen showed up at Nadia's door on a Saturday afternoon, folder in hand, already speaking before Nadia had fully opened the door. "This fence needs to be addressed," Karen said. "It's encroaching on the setback requirement, and I need you to have it moved within 30 days. "It passed inspection in April," Nadia said. "Gary came out himself. I have the signed approval." "There's been a reassessment," Karen said smoothly. "I have updated documentation showing it's out of compliance." "I'd like to see that," Nadia said, "because what I have says otherwise, and it's signed by the actual inspector." Karen's expression didn't waver. "I'll have it sent over. But I'd start planning for the fence to move regardless. These things tend to go a certain way once they're formally filed. I'd rather wait until I actually see documentation before I plan anything," Nadia said, keeping her voice steady despite the pressure in Karen's tone. "That's certainly your choice," Karen said, already turning to leave. "I just hope it's the right one." "Karen," Nadia called after her, "if there really is an updated report, I'd like the inspector's direct contact so I can confirm it myself." Karen paused at the edge of the walkway. "That's not really how this works. I'll handle the documentation." Here's a question worth sitting with. If someone in a real position of community authority told you, with total confidence, that an approval you already had in writing had somehow been reassessed, would you hold your ground the way Nadia did? Or would the weight of their position alone make you start doubting paperwork you knew was accurate? Nadia chose to hold her ground. She thanked Karen for stopping by, closed the door, and called Gary's office first thing Monday morning to ask about this supposed reassessment. Nobody there had any record of one. The county compliance office confirmed, clearly and on record, that no reassessment of Nadia's fence had ever taken place, and that her original April approval remained fully valid. Nadia relayed this to Karen by email, calmly, along with the office's direct contact information in case she wanted to verify it herself. Karen didn't verify it. Instead, within the week, Nadia received a formal HOA notice citing a setback violation, referencing an attached updated inspection report. The first Nadia had actually seen of this supposed document, along with a fine and a threat to file a lien against her property if it wasn't paid. Todd stopped by a few days later, his tone milder than his wife's, but carrying the same underlying pressure. "Karen takes this stuff seriously," he said, leaning against Nadia's mailbox. "It'd honestly be a lot less stressful if you just moved the fence a couple feet and let this go. Fighting it just makes it messier for everyone." "I have a valid signed approval," Nadia said. "I'm not moving a fence that's already compliant because of a document I've never actually seen verified." Todd shrugged. "Suit yourself. These things have a way of going a certain direction once they're filed formally, is all I'm saying. Does that sound like someone genuinely trying to resolve a property dispute, or does it sound like someone applying pressure toward an outcome that was already decided before any real verification happened? Is that just how HOA enforcement sometimes works, or is it something that deserves a much closer look?" Nadia, increasingly uneasy, requested a certified copy of this supposed updated inspection report directly from the HOA's own office. What she received back a week later appeared to carry Gary's signature, but something about it, when she compared it closely to her original April approval, looked subtly different. The letterhead was close, but not quite right, the formatting slightly off from the county's actual template. She wasn't certain enough to say anything yet. She simply kept both documents side by side in her growing folder, along with a note to herself about the differences she'd noticed. A neighbor, an older man named Frank who'd lived on the street the longest of anyone, mentioned to Nadia in passing that Karen had pushed a similarly aggressive timeline on a different residence shed a couple of years back, though that dispute had quietly resolved itself before it ever reached a hearing. "She doesn't usually let go once she's decided something," Frank said. "But I've also never seen her produce paperwork that didn't hold up before." The HOA's formal filing process took several weeks to move forward, and for a stretch of nearly 2 weeks, nothing new happened. No further notices, no additional visits from Karen or Todd. Nadia kept running her tailoring business, picked her kids up from school, and let herself hope, cautiously, that the whole dispute might simply stall out on its own. She kept her folder growing anyway, the 2 versions of the inspection document tucked side by side, still nagging at her every time she happened to glance at them. She was right not to let it go, because across the neighborhood, Karen hadn't backed off the filing at all. She'd simply moved it forward quietly, formally requesting a small claims hearing to have the fine and lien approved by an actual judge, fully expecting, based on how these things had always gone in her experience, that no one on the other side would look closely enough to slow it down. The hearing date arrived on a Thursday afternoon. Nadia brought her full folder, the original April approval, the county office's written confirmation that no reassessment had occurred, and the suspicious, updated document the HOA had sent her, which she'd since noticed had Gary's title listed slightly differently than his actual official designation. On something closer to instinct than certainty, Nadia had also emailed Gary directly the week before, asking if he'd be willing to attend the hearing simply to confirm his own signature if it came up. He'd agreed, mostly out of professional courtesy, and was seated quietly in the gallery when the hearing began. Judge Alvarez opened by reviewing both submitted documents, taking his time, occasionally flipping back a page to compare details. Karen, composed and confident, laid out her case clearly, referencing the updated inspection report, as though its authenticity had never been in question. "This is the inspector's signed report," Karen said, sliding it across the table. "Dated, certified, exactly as required. I don't see what else there is to discuss." Judge Alvarez studied the document for a long moment, then looked toward the gallery. "Is that your signature on this report?" he asked Gary directly. The room went quiet. A few other people waiting for their own cases glanced up from their phones, sensing something had shifted in the pacing of the hearing. Have you ever watched someone in a hearing present a document with total confidence, completely unaware that the one person who could actually verify it was sitting quietly in the room the whole time? Gary stood, clearly uncomfortable, and asked to approach the bench for a closer look. After a moment, he shook his head. That's not my signature. It's close, but the loop on the G is wrong, and I've never used that title on any official document. I don't recognize this report at all. Karen's composure faltered for the first time all afternoon. There must be some confusion. That came through the HOA's official file. Where did the HOA's office obtain this document? Judge Alvarez asked. Karen hesitated. I compiled it myself, based on notes from a site visit I conducted personally. You conducted the inspection yourself, Judge Alvarez repeated, and then attached what appears to be the county inspector's signature to it. I didn't forge anything, Karen said quickly. I may have formatted it to look official, but the substance is accurate. The substance being your own personal measurement, taken without any equipment, compared against a certified inspection this court already has on file, Judge Alvarez said. Those aren't the same thing, and presenting one as the other, attached to someone else's name, is a serious problem in this courtroom. Nadia calmly placed her own folder on the table, her original valid approval, and the county office's written confirmation that no reassessment had ever taken place. Judge Alvarez reviewed both, then looked back at Karen. The original approval on file is valid, signed, and unchallenged by the actual county office, he said. What you've submitted today appears to misrepresent an official government document as coming from someone who didn't actually produce it. You could feel the shift settle over the room. Not through any raised voices, but through the simple, steady weight of two documents sitting side by side, one genuine and one not. Judge Alvarez set the disputed document aside and addressed Karen directly, calm and measured. I'm dismissing this claim in its entirety, he said. The original permit stands, and no fine or lien is authorized against this property. Beyond that, submitting a document that misrepresents a government official's signature in a legal proceeding is something I'm required to refer for further review, separate from this case. This is completely unnecessary, Karen said, her voice rising with disbelief rather than authority. I was trying to enforce a legitimate community standard. Community standards don't require misrepresenting someone else's signature to a court, Judge Alvarez said, not unkindly, but firmly. Todd, seated beside her, said nothing, staring at the table. Karen glanced toward him, as though waiting for him to step in, but he offered nothing. What happens now? Karen asked, her earlier confidence almost entirely gone. This case is dismissed, Judge Alvarez said. The matter of the document itself will be reviewed separately, outside this hearing. There was no raised voice from the judge, no dramatics, just a calm, procedural outcome, exactly the way these things are meant to unfold once the actual facts are laid out clearly for everyone in the room to see. Nadia sat quietly through all of it, not smiling, not gloating, simply relieved that offense she'd properly permitted months earlier was, finally, no longer in question. Did Karen expect this outcome when she slid that document across the table with such total confidence? Almost certainly not. People who've spent years assuming their position alone would carry a claim rarely planned for the moment someone thinks to check the signature. In the weeks that followed, the HOA board, informed of the hearing's outcome, opened its own internal review of Karen's handling of the matter. Frank, the longtime resident who'd mentioned the earlier shed dispute to Nadia, brought that history to the board's attention as well, prompting a broader look at how enforcement decisions had been made during Karen's time as president. She stepped down from the board not long after, though the announcement to the community framed it simply as a personal decision. Gary's office issued a brief clarification to residents, confirming that any future inspection disputes would be verified exclusively through official county channels going forward, with no exceptions, and that any HOA correspondence referencing an inspection would need to link directly back to a verifiable county record. Nadia never sought recognition for any of it. She didn't post about it in the community app, didn't bring it up unprompted at the next HOA meeting, and when a neighbor asked her about it weeks later, she mostly just said she was glad her fence and her family's peace of mind were finally settled. She'd simply wanted the fence she'd properly permitted left alone. In the end, that's exactly what happened. At the end of the day, this was never really a story about 2 feet of fence line. It was about what happens when someone in a position of small community authority assumes no one will ever check the paperwork closely enough to notice something doesn't add up, and what happens eventually when someone finally does. Nadia didn't win this by arguing louder or escalating the conflict herself. She won it by staying calm, trusting her own documentation, and quietly following one small inconsistency until it held up or didn't in front of a judge. Sometimes that patient approach really is what it takes. If you enjoyed this story, go ahead and hit like and subscribe if you want more real HOA and courtroom karma stories like this one every week. There's plenty more where this came from. Have you ever dealt with someone in a position of small authority who you suspected wasn't being entirely straightforward with the paperwork? Tell us what happened in the comments below. We genuinely read every one of them.